Good morning, everyone. If I can steal your attention for a moment. Anyone still coming in, please find your seats whenever. No stress. This is a nice cruisy room, I think. We can see everyone. And we've got a beautiful view. It's always nice when you can look out and see what's happening outside rather than being closed in walls. So welcome to the B2B room, the 11th year of Digital Adelaide for 2025. My name is Chanel Franklin and I'll be looking after you in this room. I have a wonderful speaker coming up, and I know you're all very excited to hear what he has to say. It is Paul Gordon, Wallman's Lawyers, our next speaker, who has built his career at the intersection of law, tech, media, and innovation. Paul is one of Australia's leading experts in social media and privacy law, with nods from Doyle's Guide and Best Lawyers Australia to prove it. He advises everyone from startups and digital disruptors to big brands, health organisations, media agencies and government. Basically, if it's pushing legal and digital boundaries, Paul's probably been involved. He's a sought-after speaker at tech and media law events, a regular on radio and a published voice on how law is evolving alongside the internet. We need this man and we need his knowledge. Please make him feel welcome. Paul.
Do I have a clicker? I should have asked that. Thank you. So firstly, it's great to be here on Ghana Country, speaking to you all. Welcome back to Digital Adelaide. And yes, you have picked the right session. This was the right one out of the two choices that were made available to you. So well done on that one. Today, I've got a few things that I'm wanting to cover in relation to the ways in which the law has changed in the last 12 months. But before I do that, can I just get by show of hands, who's seen one of my presentations before? Cool. People who are new? Excellent. And the usual question, people who don't like being asked to raise their hand? Excellent. Thanks, Jen. So because this is the 11th year that I've presented at Digital Adelaide, there are some things that I'm not covering in as much detail as I might otherwise have done. So if I gloss over a topic and you think, Paul, I really don't understand anything you just said, feel free to stick your hand up and I can go in more detail, or send something through the Slido and we can get questions at the end. There are some prizes this year. I always promise prizes and never deliver them. I actually have things that I will be giving out today, so be ready to interact. So what have I got on my slide? So the first title for this presentation was Battle Lines, the Fight for Control of Social Media. Is tough call between that and the most fun you could have in your briefs. That is a law joke. You are welcome. For those who are uninitiated, the bad jokes are here to stay. Lean into the experience. It's better for everyone. I am a lawyer, I promise, but this is not legal advice. If you need legal advice that is tailored to your personal needs or your organization's needs, please contact a lawyer. There's one there. I do also some great MS Paint commissions. If no one has ever taken me up on this, I'm really devastated. Every year I spend minutes, literal minutes, putting these things together and no one has asked me to do one for them. Very upset. But feel free to get in touch on any of those means. And today we're going to be covering all of the changes in privacy, because that's been probably the biggest thing that's happened over the past 12 months. We're also going to be talking about AI and how that's been developing. The social media ban, the Prime Minister was up today speaking about that, which is great, seeing as I sent my slides in yesterday. Jerk. Personal slide on me, obviously. And I'm also going to talk about some of the court cases that have arisen over the past 12 months. But before we start, there is a scandal that needs to be addressed. I mentioned it briefly. I'm glad that one of the organisers of this event is in the room so that they can hear from all of you, the people, as to how this injustice is affecting all of you. Kimberly Reddy posted about what she was doing on her Digital Adelaide schedule. And today, instead of being in this, the correct room, she is over in the William McGarry room listening to Andreas Versteeg. And yes, she was torn because I was speaking, but she still made the wrong call. It really was, not Sophie's choice, but Kimberly's choice. You will see Ryan Jones there in the background, just glaring at me. And I just think it's unfair. I think that this should not happen, and it's not the first time. Last year, again, we had 2 presentations. People could not come and hear what they needed to hear. They had to choose. And so, for that basis, and this is. I promised my wife I would turn around while I'm doing this. This is not a strip show, I promise, even though I did earlier in the year, host a burlesque. There we go. So I'm asking for you all to support me in my guerrilla campaign to give Paul a keynote. This is very important. And the prizes today are some Give Paul a Keynote. There you go, Jen. Give Paul a Keynote tops. We have multiple sizes. They're amazing, beautiful t-shirts that I will be giving out today. Please do wear them around. And obviously in your feedback survey for Digital Adelaide, let's just spam them with the words Give Paul the Keynote. I promise that is as close to stripping as you will see from me ever. Now, the other thing that's happened this year is that I was laid down a challenge. Rubina noted that we have unicorns, magnets, sharks, princesses, and ancient books appearing. Am I feeling the pressure? No, I am not. Because in this presentation, you will see on these slides one of each of those things. And so you're going to be playing bingo. These tops are going to be given to the people who first call out when we hit bingo on all of those things. So watch the slides carefully. Those in the back, I'm sorry, this is going to be difficult for you. But I'll give you a moment to take a photo with your phone if you want. We're going to have unicorns, magnets, sharks, princesses, ancient books, dentists, frenemies, which is kind of like conceptual, space, and art. All right, we all good? So let's actually now, I was telling my wife about this. She said, are you actually talking about the law or are you just making stupid jokes? Like, I think people are happy either way. But let's get into it. This is a question that I've asked every year for the last 11 years. Is there a right to privacy in Australia? And the answer to this question for the first time in the last 11 years has changed. Previously, when I asked this question, the answer was no. Australia did not have a right of privacy. It was instead regulated by the Privacy Act. So the Privacy Act regulated how certain businesses and people handled personal information. But if you weren't a company earning more than $3 million a year, or an individual, if you weren't in health service provision and if you weren't dealing in data, you could do whatever you wanted with personal information. Now, however, change has arrived. At the end of last year, the federal government brought to Parliament, and it was enacted, changes to the Privacy Act, which made the most sweeping amendment since 2014. Before November 2014, we were told that they'd be making a number of changes. They signalled through a report what changes would definitely be made and what changes would probably be made following consultation. And the first of those changes was penalties have been amended. So interestingly, whilst they have increased the maximum possible penalties that you can get for a breach of privacy, they've also introduced some lower level penalties. And that's important because one of the reasons that we believe that the Privacy Commissioner very rarely penalised anybody is because they only had a sledgehammer. The penalties were super high, and so if there was a moderate level breach, they didn't really have much room to move. Whereas now, we are looking at having much lower penalties, $66,000 for breach of privacy up to $660,000. And that, I think, is going to mean a greater likelihood of penalties being given out. In addition, they have given the Privacy Commissioner and the Information Commissioner the ability to issue penalty notices. And so that is, yes? photo and could do what I like with it. Now, if I had a reasonable expectation that in my own home I'm in a light of seclusion, you doing that breaches my privacy, and potentially in a serious way. From an online perspective, it means that things like monitoring of conversations that people are having online could, again, fall within this net. Because if I have an expectation that the conversation I'm having with you online is private and someone hacks into that, that is a breach of my privacy. Which means that as businesses, we have an obligation to make sure the security of our messaging platforms is sufficiently high. It is important, though, that I did have a reasonable expectation of that privacy. If I'm walking down London Mall and you take a photo of me, too bad. There's no expectation of seclusion in a public place. If I'm posting on a publicly accessible forum and my information is taken, I don't think that you could say that that is a serious invasion of my privacy because it was already publicly available. It's going to be most relevant to organisations that have one-to-one messaging or group messaging, or if you have a private forum. So if there are any disability service providers, for example, you could imagine that that would be a situation where, whilst yes, it was available to a large number of people, they were people within a community. I might not have been content to be so open about my personal struggles if it was publicly available to people who weren't part of that community. So just something to keep in mind when you are considering the types of platforms that you're running. The invasion of privacy must be intentional or reckless and must be serious. So that means that if you have been taking reasonable security precautions, even though it might be a serious invasion of privacy, you will not be liable. If, however, you are reckless, you don't have appropriate encryption on what you're doing, you haven't talked to Ryan Jones about how your website should be structured and secured, then that is potentially a risk for you. It must also be serious. If someone captured a post about my favourite Foo Fighters song, that's probably not necessarily serious, but if it is about my sensitive information, absolutely it could be. There are exceptions that can apply, so those are the things like police are allowed to invade your privacy generally, most situations. Interestingly, you don't need to show that there's been damage, and this is where the crackpot issue comes up. I don't need to demonstrate that I've suffered any loss. I don't need to demonstrate that I've even been overly upset by something. If I can say that it's serious and you were reckless, that's all that I have to do to get my damages from you. Interestingly, only individuals can sue for this, not corporations, which means that if you have corporate information, you can do what you like with it, basically. Only the individuals involved could actually take action. So this is quite a significant change, and one which you need to be thinking about in terms of your privacy practices. Even if you are not caught by the Privacy Act at the moment, so if your organisation has revenues of less than $3 million a year, this still applies to you. So it's really important to be aware of it, even if you aren't otherwise what's known as an APP entity. It's Australian Privacy's Principal Entity. But the real challenge is, what does serious mean? Because there is no real guidance. They have given a few little bits and pieces of information. So should the defendant have known that the offence would cause distress or harm to dignity? Were they motivated by malice when this happened? What will be interesting to see is if there are any successful prosecutions of an innocent third party as opposed to the actual perpetrator of the invasion. The fact of the inclusion of the word reckless makes me think that it is entirely possible. So something very much to be aware of. Another privacy change that's come in is some further loosening of the rules in terms of overseas data flows. So prior to this change coming in, if you send information overseas and something went wrong with that information, you were liable. This now allows the government to select countries and say by regulation, these countries are as strict, if not stricter than Australia, and therefore you are safe working with businesses in those jurisdictions. Now, we've kind of taken a de facto view of this today. So we've generally had the position that if you are having data processed for your business in Europe or in California or even in Singapore or New Zealand, that's probably okay. And the reason for that is that the GDPR in the EU and in the UK, the California Privacy Code, the Singapore Data Protection Statutes, and the New Zealand Privacy Act are all pretty comparable to the Australian privacy law. And so if you were sending information over there, you probably were in a reasonably defensible position. This is just going to allow the government to make that even clearer, although they are yet to actually prescribe any countries. It also allows the government to declare that a data breach has occurred and make the sharing of the information, the subject of that data breach, unlawful. So this arose in a case involving a law firm, H.W. Ebsworth, who suffered a massive data breach. And when that happened, they went to court and sought an order preventing anyone from accessing this information, which was novel because they didn't know who it was. Normally, if you go to court, you have to say, person X has my information, and I want to restrain them from doing anything with this. All they knew was anonymous user with Bitcoin account XYZ had their information. And so they got an order against the world saying no one was allowed to publish or disseminate that information. This change to the law allows the government to make a declaration to avoid people having to go to court when that occurs. So, common sense thing to do. In general, if someone gives you a treasure trove of stolen information, probably don't take it anyway, like whether there's a court order or not. Bit of a moral question. I know I'm a lawyer, but I'm talking about morals, but yeah, probably morally you shouldn't do it. Is anyone here in their business utilising AI for decision making? Yep, a couple of people. There is now an obligation on you to explain to the public at large and your end users how that AI decision making is happening. There is an AI automated decision making transparency law that has now come in. And that means that if you are using AI to filter resumes as part of recruitment or to target advertising, you need to be able to explain as part of your privacy statement what is happening and how. Yes?
Sorry, I'm just wondering, because the EU also has a similar thing. Does it cover similar risk categories, or is it just blanket for any type of decision making?
So here it is blanket. So it is not taken the EU model in that respect. So it's actually quite draconian, and it does mean that you technically need to be aware of how the AI works. And that's why we start talking about, are you using a black box AI system or a clear box AI system? Do you have an AI transparency statement from your AI provider that explains how things are being decided? This is really important if you are thinking about doing that, and many businesses are starting to look at it because it is a very useful tool. So it's just important for you to be aware of how that system works. Other changes that have come in, so there is now a criminal offence of doxing, which is great because doxing is abhorrent. And they're also consulting on the Children's Online Privacy Code. Now, is anyone here involved in marketing to children? Cool. So you guys don't need to worry about that. But in short, they're currently consulting on whether or not what restrictions are required, what kind of child consents will be needed to be given in order to collect information or use direct marketing in relation to children. They are still considering criminal offences for malicious breaches of privacy, greater penalties for breaches, and changes to the research exceptions. These, however, are the major changes to come. So up until now, we've had the small business exception. So if you were earning less than $3 million a year, you were exempt from the Privacy Act. They are looking to remove that exemption. If you currently are using employee records, so information about your employees or job applicants or past employees, then the Privacy Act doesn't apply to them. They are looking to remove that exception. They're looking to increase the standards required for privacy notices and privacy statements, and a requirement that the minimum amount of data collection necessary for your business is mandatory. But these are still being consulted on, and whilst the laws came in late last year and we thought they'd probably be consulting by now, they have not yet started. So whilst these are definitely something the government has accepted in principle, I don't expect them to be introducing any legislation anytime soon because they have promised to consult, and it would probably take at least 6 months for them to do so. I would expect this might be the end of next year. So come back to Digital Adelaide 2026 and I'll tell you all about it then. They're also going to create a right to seek an explanation as to why your personal information has been collected, the right to be forgotten, and an unqualified right to opt out of direct marketing. So those will be significant changes, particularly in a marketing context, but don't panic just yet. Harvest all the data you can right now whilst it's still lawful, and basically, let's just cut that out of the recording. Okay. So now that we understand what the laws are and how it's happened, let's look at what happens when things go wrong. This was in the news this week, not great. We saw Advance, everybody's favourite right-wing nationalists, using unblurred footage that they'd taken from school websites of teachers and kids. I think they blurred most of the kids' faces, not all, most of the kids' faces, and that has been raised as a privacy concern. It's also a copyright concern because they're making use of someone else's photography, but that is absolutely a breach of privacy and one which they will probably be held accountable for. Who here flies with Qantas? Are we all feeling really comfortable with how they're looking after our data? I know I am. That is going to be a very interesting data breach, and it's one which makes you realise how vulnerable systems are, because that was, from the reports that we've been reading, based on a call centre employee receiving a call from someone saying they were from IT support, saying, hey, could you just give me this information and click here and do that, and gave access to the entire Qantas system. Could happen to anyone. It's one of those things. Social engineering is the greatest vulnerability for most systems. And when we look at the data from the Information Commissioner about the breaches that have happened over the past 12 months, the vast bulk of issues have been arising from malicious actors. It's something like 49% of data breaches were malicious actors, which is, I would have thought it'd be human error. That's only 29%. So malicious actors is the biggest issue, and social engineering, spear phishing, is the greatest contributor to data breaches. So talk to your people, I guess. It will be interesting. Qantas is an interesting tale because they've not been overly forthcoming with what's happened. And I'm not sure that's the best PR exercise. You guys are the experts in marketing, but it hasn't filled the world with confidence. And I think it'll be interesting to see how much that has been legally driven, because often you don't want to admit anything in these early stages, particularly when there's this new sort of serious invasion of privacy out there. But it has seemed like an interesting exercise. So moving on from privacy to developments in AI. Just to remind everybody that in Australia, it is very likely that training AI is an infringement of copyright, and that the outputs of AI are not owned by anyone. I can go into a whole lot of detail. My slides involve a crested macaque and a camera, but trust me on these ones, that's how it is in Australia. But that's not how it is in the rest of the world. About a year and a half ago, a number of authors, the most prominent of whom was Sarah Silverman, who had written a book and a musical called Bedwetter, very, very funny, had sued OpenAI on the basis that those works had been utilised to train their AI. They have just, the case isn't fully over, but the judge has held against, sorry, this was Meta, not OpenAI, wrong conglomerate. Effectively, they argued, and it was a very interesting argument that the judge just hated. The authors argued that by utilising the works, Meta had deprived them of the right to to seek license fees for the training of their AI. And the judge said that's not a thing. Authors don't generally just offer to give up their stuff to be used for training of AI. And therefore, so there was insufficient evidence that that market was actually, that it existed or that it was damaged. They also found that where an AI makes sufficiently transformative works, those works do not infringe the underlying IP of the authors. However, the court did say it is hard to imagine that it can be fair use to use copyrighted books to develop a tool to make billions or trillions of dollars while enabling the creation of a potentially endless stream of competing works that could harm the market for those books. So basically what the court said is, Sarah Silverman, your lawyers got it wrong. They had a stupid argument. I don't like it. If they'd done this argument, you would have won. And so I'm wondering if she's going to keep those lawyers. I don't know. But creatives in the world can take some comfort from the fact that this judge has said, effectively, because you could ask AI to reproduce bedwetter, that would mean that you were effectively creating a facsimile of that book, and that would harm the competition, and therefore the fair use exceptions that the AI companies were relying upon wouldn't necessarily apply. Now, the reason why this isn't a thing in Australia is because we don't have fair use. We have fair dealing. And fair dealing requires for you to be able to use someone else's copyright works for you to fit into a number of specific categories. And whilst research and development, so research and study is a category, it has to be for personal research and study, not for commercial development. So I would say that if there's any evidence of an AI company training AI on the internet in Australia, that would be a really great case to try if you were an author. But most AI development is not happening in Australia, and therefore we haven't seen any of those cases. We have, however, seen Disney and Universal Studios suing Midjourney AI. These are all Midjourney developed images, which look awfully similar to WALL-E, How to Train Your Dragon, Star Wars, and Shrek. You can see that the Midjourney output of Homer just looks like he's lacking a soul. I think he's just really, like, look at those eyes. Creepy. Bingo items in this slide. They basically are complaining that Disney and Universal, who have spent countless decades bringing joy to families, literally these are the words that are in their pleadings, it is insane, about how angelic these multinational companies apparently are, and they're being hurt by the evil and ridiculously bad Midjourney. They are currently suing. It'll be interesting to see what comes out here, because this is the creation of true facsimiles of the actual underlying works. I don't see how you can say that that image of Homer doesn't replicate the Homer Simpson copyright. The UK government have attempted to make things easier for AI, and they tried to bring in some reforms to enable AI development, but the director of Bridget Jones' The Edge of Reason, who is now a peer in the House of Lords, has led a rebellion against it, and so they haven't actually got those things through, which I just thought was amusing that that's who it was who was running that. In my last 2 minutes, I'm going to talk about the social media ban. I've run completely over time. So whilst youth media bans exist elsewhere in the world, Australia will be the first to bring in a countrywide one. It is coming in December. It will require anyone who runs a social media platform to have an age restriction for the creation of accounts. Keep in mind that if you have a service that has a sole or significant purpose of enabling online social interactions between 2 or more users and allow them to post and link to content, you are a social media provider. If you run a forum, a blog, any kind of owned media platform within your business, you are caught by this, and you must have restrictions on the creation of accounts. If you run any of those things, you have until December to comply, so a few months, and you must have mechanisms to prevent them from creating accounts on the platforms. In my last minute and a half, Meta got sued and settled for $8 billion arising from Cambridge Analytica. A Melbourne GP was found guilty of professional misconduct on the basis that he had posted comments which were quite awful about abortion and LGBTQIA+ content. We had a situation where a viral furor over a missing dog did not entitle the parties involved to $250,000 worth of damages over posts about missing dogs. Council members, this is a very important one. A ratepayer group on Facebook posted a bunch of truly defamatory things about elected members. And the elected members sued for defamation. It was held that because the forum in which it was happening was not one where the elected members would ever have any level of reputation to be damaged, they were not defamed. So effectively, because the purpose of this group is just shit talk a bunch of elected members, no one really would be taking it seriously, and therefore no damage was suffered by the elected members, which I thought was fascinating. So that means that if you've got a group that is just a bunch of people who already think that person X is terrible, they can post what they like because it's not going to lower anyone's opinion of the person who's being defamed. Yeah, fascinating. Andrew Tate has sued an Adelaide-based influencer for defamation, which is amusing. Is his reputation really able to be harmed? Really? And now I think with minus 5 seconds to go, we are up to questions. But before we get to questions, who got bingo? Anyone? Come on. I've got 3 t-shirts to give away, and I'm just going to otherwise just have to randomly throw them out. These were your things. So there was a unicorn on the table in the school picture. There was a magnet in the robber's hand. There was a shark and a princess in the Little Mermaid image. Come on. There was an old book on the courtroom counter. There was a dentist randomly in there for no reason. Frenemies, you've got Hugh Grant and Colin Firth. Space, and the artwork in the classroom. Okay, well, I'm going to give you one anyway. So I've got a large and 2 mediums.
I don't know what the presentation was like, but I kept my eyes focused for those things.
Excellent. Have a t-shirt. Anyone else get anywhere close? Yes. Oh, enjoy. Amazing. I'm going to come closer because I was avoid microphone feedback. Sorry. Awesome. So, questions.
Please give Paul a round of applause. Wow. A legal brain built for the digital age. And I think the common thread is that because things are moving so fast, we can't almost keep up with how much things are changing. So we need your brain. We almost need you like a little Jiminy Cricket on our shoulder to say, Paul, help us get him out of these sticky spots. So I remember I produced a TV show about 10 years ago, and the advice I was given was just do it and apologise later. Can't get away with that now.
Look, you can try.
It's to do with music rights, to be more specific.
Yep.
You can use that song. That's a really good song. Sometimes we don't want to use the free music. We want the good music that's out there. And they said, just chuck it on it. Don't worry about it. And I thought, and something in me said that is not right because obviously it's an artist's music. But from a legal perspective, where do we sit? We're producing content all the time on social media.
So the answer is absolutely take the risk. That's good for my business. Cool, do it. Depending upon the context, if you were doing something that was, for example, using a very short clip, that might be okay. But in particular, you would want to have a level of criticism or review of that music. So I was working for a company developing a podcast, and it involved talking about how songs were made. Yeah. And so that was fine because they were playing little samples of it for the purpose of commenting upon the music. They weren't just playing the whole track, and they fell within one of those fair dealing exceptions. But if you don't fall within one of those fair dealing exceptions, that is definitely copyright infringement if you're using a substantial part of the track, and it is problematic. Now, what you can do these days, though, is on certain platforms, so like on Insta or YouTube, where they have an existing agreement with the license holders, you can make use of those tracks because YouTube or Meta are paying for those rights. And so if it lets you add a track natively to something, then that's generally okay.
Like Instagram, for example?
Correct. So that's generally fine because as part of the monetization process, little cuts are being sent through to Sony Music or Universal, whatever it is. But outside of those owned platforms, it is very risky to make use of that.
So better to just play it safe, trust your gut with those kind of things, I think.
Absolutely.
Social media. So we're kind of forced into this area of creating content now. Even businesses that wouldn't have touched social media before are being forced into this world now. As far as taking video, panning around people in the background, children, should you be handing out disclaimer forms and things like that when you are taking those videos? Like if we were here today and someone is promoting Digital Adelaide, should there be something to do with people saying, you do have the right to use my image, even if it is just a pan shot? Talking more businesses specifically.
Yeah. So the answer is that depending upon where you physically are, no, you don't need to do that. And the reason you don't need to do that is that in Australia, there is no right to your own image. That means that if I'm in a place where I don't have that reasonable expectation of seclusion, I can have my image taken. And so if someone was taking a pan shot of people being here in Digital Adelaide, you're in a place where it is reasonable to expect people might see you and might take your image. The only thing that would be potentially challenging from a legal perspective is if it was used for a promotional image and it implied some kind of endorsement that you did not offer. So if you thought that this was the worst conference you've ever been to and that Paul guy was terrible, firstly, maybe not, then you might be able to object saying that you didn't endorse it, but in reality you were here. You were physically in the room. It's not false to say that you were here at the event. So I think that in general you don't need disclaimers, but it does come down to that gut thing. I often get people asking, well, if I'm taking images of kids, don't I need to get parental permission? And the answer is no, from a legal perspective, but from a moral perspective, yes. So I would generally say, if it is practical to give out waivers, I would do it. If it's impractical, if it's just like a crowd shot and you're scanning past and you're not actually focusing in on a particular person, I probably wouldn't bother.
Great, it's good to know. I don't think there's anyone in this room who wouldn't be using AI at some point in their business. Nodding along, it's helpful. It cuts the time down. It sometimes expresses things, or at least leads you on to the next point of, oh, I like how they've reframed that. If I just add my touch to it, then it's great. So if we're producing books, marketing material, things like that, are we at risk of just allowing AI to do that for us and republishing that as our own work, saying, let's say, for example, myself, I've produced a paper and I say, by Chanel Franklin, AI wrote the whole thing, but I've now got my name on it. Where do I sit?
Yeah, so this is where we come into an issue of ownership. In Australia, based on a case called Ice TV against Channel 9, High Court, there you go, I'm proving I'm a lawyer, they basically found that if there was a computer-generated output without sufficient creative human interaction with it, no one owns it. So you might be able to put out there that that's your work. Firstly, is it misleading and deceptive to say that you wrote it when you didn't? Secondly, if someone took it and used it for something else, you couldn't stop them. So it's very dangerous to use pure AI content from an ownership perspective. The other issue that we're seeing, though, is at what point does it change from being AI content to being your own? So if you get AI gives you the marble and you then sculpt it into something, that may well be okay. We actually saw a case I talked about last year in China where someone was able to claim ownership of an AI image because they had used over 150 different prompts to refine it. So even though it was entirely AI produced, they did not draw a single thing. They had said, okay, change the lighting slightly in this quadrant, alter the color of the sash, thin it out, etc. And the court basically said, well, how is that different to Photoshop? It's just that you are using words as opposed to other tools to make those changes. And I think that is likely to be good law around the world. I think that if you can demonstrate that through prompt manipulation, you have had a creative input into whatever the AI system spits out, you may have a level of ownership, but there is going to be a lot of grey. And so we need to be very mindful of the risks in using AI and also disclosure requirements, because you can't outsource your professional judgment to an AI system. There are plenty of cases, particularly with lawyers. We are terrible for this, where lawyers have gotten into trouble, including in Australia, including in the last month, for submitting to court citations that say, this case said this, that, and the other, when the case literally did not exist. Now, I've just been given the wrap it up, so I'm not sure if that means
One more final question. There's also one saying it's a little bit cold. Can we turn the heating up? So we'll get onto that. I love that. It feels like the law is still catching up with all the new emerging tech. Will it ever catch up, or we continue to chase our tails? What do you think?
It will. There is no way the law will properly catch up. The way in which the internet is regulated is based on a bit of our constitution about lighthouses. So what happens is lawyers and parliaments retrofit existing laws where we can and look for new laws where we can't. It will constantly evolve, which is great for me and terrible for all of you, because you have to keep on coming and listening to me every year. But I would say, unfortunately, it's a constant battle, and as technology continues to change and challenge how things are done, the law will constantly be trying to catch up.
And we can't put you on the bottom of our works and say, Paul said this was okay. So suddenly we're out of the legal loophole there.
Unfortunately not.
Paul Gordon, everyone. Thank you so much. Brilliant. We'll have a short few minutes for the walk time, and we'll see you soon for our next incredible speaker. Thank you.